While we're looking at the Divorce Act, we have to focus on one concept: best interests of the child. So in addition to including and defining family violence, the bill further elucidated the concept of, we've all heard it, the best interests of the child. Best interests of the child is statutorily the only test. Section 16 sub 1 of the Act says that, quote, the court shall take into consideration only the best interests of the child of the marriage in making a parenting order or a contact order, end quote. The obligation on the court is not new. It's not new here, focusing on BOIC, but it is still noteworthy that BOIC, best interests of the child, trumps all else. We cannot leave this topic of family violence without turning to another subsection, which is 16 sub 3. That tells us to consider all factors related to the circumstances of the child, including and then it goes on to provide a non-exhaustive shopping list of factors. What is germane for our discussion today, because we're talking about family violence after all, is sections 16.3J and 16.3K, which are up on the screen now. Notice the current focus on the child here. Sub 3, determining the best interest of the child, the court shall consider all factors related to the circumstances of the child, including J, any family violence. That's any family violence against anybody in the household or elsewhere even, and its impact, among other things. Where? Its impact on the ability and willingness of any person who engaged in the family violence to care for and meet the needs of the child. And sub 2, the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate on issues affecting the child. Remember I said that shared parenting wasn't a given? Well, this is one of the reasons, because of family violence, another person, i.e. the other spouse, cannot cooperate with you because they fear for their safety, then shared parenting, whether it's decision-making or time, is not necessarily a given. Sub K, watch sub K here. Watch the reading of that. Any civil or criminal proceeding, order, condition, or measure that is relevant to the safety, security, and well-being of the child. Does it say any criminal conviction that is No, it doesn't say that. So you have an interim judicial release provision. It's relevant. You have a diversion program. Let's say you're charged and they agree to put you into diversion and you do whatever the requirements are in that diversion program so you don't get a conviction. You can't say in family court, well, I didn't get convicted. Right here, sub K, it's here. So what are the takeaways from these parts of the Divorce Act if I haven't hammered it home sufficiently already? 16 sub 3 gives us a non-exhaustive list of factors that the court must consider to determine the best interests of the child. There is room here to expand on any kind of bad behavior, in my view. The Divorce Act brings back bad behavior into the statutory criteria. Let that one sink in. The Divorce Act brings back bad behavior into the statutory criteria. When the Divorce Act was amended, 1986 was one set of amendments that stands out. When provincial legislation was amended, 1978, 1986. Earlier than that even. Yes, I'm showing my age, aren't I? We were taught, us young family law lawyers, we were taught, don't engage in besmirching the other side, talking about their bad behavior, unless it is relevant to any of the issues. And until these amendments that was the law, sometimes honored more in the breach than otherwise, because there are situations, even before the Divorce Act was amended, where family violence would be relevant for sure, for sure. But I always believe that you don't put in extra things, extra elements of the violence into pleadings, because where there are children, these parents are going to have to parent these children going forward. And we as lawyers are not judges. We don't know what's true and what isn't true. We don't want to poison, we should not want to poison the atmosphere. The Divorce Act brings back bad behavior into the statutory criteria. Now I think a lawyer is obliged to plead the bad behavior.